Good morning, welcome all to our autumn employment law update, and we're Judy and I are very pleased that so many of you could join us today. Just before we start the session, just a bit of housekeeping to make you aware of. The webinar is being recorded and the recording will be available afterwards, but please don't worry, all attendees are muted with your videos off. It's just going to be me and Judy that are recorded, preserved in video form forevermore. If you have any questions during the live webinar, please do submit them in the Q&A box at the bottom of the screen. There's not a chat box function available on this webinar. We'll answer as many as we can, either as we go or if we have time at the end of the session. We're also going to be launching a couple of polls during the session, so please do participate and let us know about your own experiences and your own institutions about the issues that we're discussing today. And just to let you know that after the session, you'll have the opportunity to give us some feedback, including in respect of future topics you'd like to see going forward in these webinars. So what are we going to cover today? Of course, many universities have now returned to in-person teaching, either fully or as part of a hybrid model. I'm going to start by looking at some of the ongoing tricky issues that are facing universities in respect of staff, issues that we're experiencing from our clients. Equality, diversity and inclusion, it continues to be high on the agenda in the sector and also nationally, so Judy will be exploring this in a bit of detail. And my experience recently is that often universities are facing increasing claims from individuals alleging whistleblowing, dismissal or detriment, so I'm just going to give a quick spotlight on that complex legal area. And we're just going to finish having a quick look into the future, looking at the possibility of industrial unrest in the sector currently, and also what the future holds for employment tribunals. So we'll start with a quick poll for everybody to make sure that the technology is working. So yeah, just wanted to ask really, what are the most challenging return to campus issues that are on your desk? And there's a list there for you to answer. Okay, so by quite some margin, the biggest issue is staff reluctant or refusing to return to campus, and I think that reflects our experiences as well. But also there's a lot of issues in terms of mental health and well-being, and we've certainly seen that as a result of the pandemic. Less of an issue is staff working from overseas, but we've certainly had a few complex issues in that area. Great. I'm just going to close that and let's go on to talk about some of these tricky issues. So early on in the pandemic, in the higher education sector, we had to move pretty rapidly, didn't we, to deliver online teaching. And we're now at a point, and that went pretty smoothly actually, but we're now at a point in the UK government's roadmap out of lockdown where campuses are reopening and increasing number of students are returning and the staff are returning to deliver in-person teaching. But of course, there are many challenges in managing that return of staff to campus, particularly in light of the different experiences that we've all experienced as a result of the pandemic, and I include anxiety and stress about returning in that. As you can see from the next slide, there are many challenges, issues, and there will be more that apply in this. I'll start by noting that many of these areas on the slide here are covered very expertly by UCEA in their Managing Staff Return to Campus guide, which includes many very useful case studies from various different institutions, and it's well worth a read if you haven't already. So I certainly commend that to you. I'm just going to focus on a couple of these issues. We haven't got time to go into them all in any great depth today, and it's the areas that we've had most queries from an employment law point of view in the last few months. And one of the main issues we've had queries about is staff overseas. I suspect because it's such a complex area, and you can see that from the slide, there are numerous potential pitfalls that apply to staff working overseas. Now, they may have been stranded overseas at the start of the pandemic, or they may have returned perhaps home to an overseas territory during the pandemic and provided some work overseas. And either the institution wasn't aware that they were working from overseas, or a request has been made to work overseas. And we're still seeing queries now about staff wanting to continue at least some of the time to work from overseas. Some employers look at these sort of potential issues and don't take the risk, and just have a blanket policy of not allowing employees to work from abroad, but others want to manage staff relations and give what they can. And for example, my brother-in-law, he spent the entire summer working from Italy. All right for some, but it is a risk. And generally, before you okay any request for a staff member to work from overseas, careful due diligence is required before agreeing to that request. Perhaps the main issue on these slides, that's the biggest potential risk, is tax and social security. Depends on the amount of time that's spent abroad and where they're working from. But local tax and social security obligations could well be engaged from a member staff working from overseas, even though employed by a UK employer and on your PAYE system. And the tax social security costs could be higher in the overseas territory, and you could end up owing both UK and overseas tax and social security in both jurisdictions. Although not usually, because normally there's a double tax treaty that prevents double taxation, but even that is complex to unravel. Another issue, of course, to be aware of is immigration. The employee will be subject to immigration requirements of the overseas territory that they're working in. If they're a national of the country in which they're going to be working, that should usually be no issue. They will likely be permitted to live and work in that territory. But if not, if there's no pre-existing status, such as my brother-in-law when he was working in Italy, it's highly likely that work will not be permitted by the immigration rules of that overseas territory without an application for a visa. And whilst international travel is now getting much more straightforward, you'll find that they can't work unhindered. So entry to the country as a visitor will rarely allow you to work. Instead, you'll have to have a right to work visa to remain and to work in that territory. And if you get that wrong, that could affect not just the current travel, but also any future travel as well. And it can have serious consequences both for the individual and for the institution, including possible criminal liability as well as civil. Excuse me. And this is certainly something that we would raise with local lawyers. We've got contacts in various different jurisdictions around the world just to check what those requirements are. You also need to check UK visa considerations. If an employee is a migrant worker in the UK holding a UK visa, if they spend significant time outside of the UK working, this has a potential to impact on their status here. And depending on the circumstances, how long they're away working for, this could serve to automatically withdraw the employee's current UK visa or could prevent them from meeting the requirements of a future application. So it's very important just to understand the obligations and the requirements. Another issue that we're seeing is employment law. They should be subject to UK employment obligations and rights, and as they are employed by a UK employer, work in the UK normally, but also they could be subject to mandatory employment law rights in the country that they're now overseas and in that they're working in, such that the organisation would need to adhere to those, and they could be more beneficial to them than equivalent UK rights. So that's something again that we can get local labour law advice in respect of. Another issue to make you aware of, pension. It could be that the employee is considered as no longer ordinarily working in the UK. If so, it may be that the employee would not be eligible to remain in membership of the institution's pension scheme. An alternative pension provision may need to be provided. So again, you need to check with the trustees of the pension scheme whether they can still be contributing to that pension scheme if they are working abroad. But perhaps the biggest issue, and not a legal one really, is the student experience. Particularly if the institution is committed to resumption of face-to-face teaching. Clearly, allowing staff to work from overseas is going to be problematic in that sense. And there's a consistency of treating staff in the same way. If you're expecting staff to work from campus, then you're not expecting people to be delivering lessons over video from overseas. But even if it's non-academic, there could be an issue of quality and messaging to other staff if academic staff are being required to work from campus. Now, just looking at some practical considerations in this area. There's another considerations that apply from both an employee relations and a management perspective. They're going to require some prior planning in relation to managing employees who are working abroad. And in brief summary, ensure employees know that they need advance approval before working abroad. It's amazing how many just assume that they could work from abroad. You don't really want them approaching the institution after the fact. Many of the problems will have already arisen. And be definitive on what they are doing, where they are doing it, and how long they are doing for. Record that in writing. Review your home and remote working policies. Consider if they need to be updated to include sections about working remotely from abroad. And when you do get requests from employees and prospective employees, treat them consistently and fairly as possible to avoid any possible complaints of unfair treatment or discrimination. Do beware of blanket refusals, because there may always be specific needs that an employee has that you need to consider that relate to their personal circumstances and may give rise to protected characteristics and possible discrimination angle there. If in doubt, take local tax and employment law advice. It can be reasonably expensive, but it is a risky strategy if you don't take that advice. On a practical level, consider how the employee will be managed remotely, taking into consideration the possible differences in any time zones and how you communicate with the individual, and also ensure that the employee has appropriate and secure equipment in their possession in order to carry out their role remotely. And the final point on this, really, agree to time limited working from abroad only, making it clear that it is temporary, and record any agreement with them in writing. Moving on to an issue that was high on the poll as being an issue for many of you refusing to attend campus. Before the session today, I had a quick look at the Office for National Statistics report on hybrid working. It's an interesting difference in opinion between employers and employees about the future of work. A lot of businesses expected 75% or more of their workforce to be working back on campus, back in the office, full time in the near future, versus a very large proportion of those currently who are home working at the time of the study, which was back in April, May of this year, thought they would spend the majority of their future time home working in the future. So something has to give between the different expectations in this regard. And we've heard many examples of staff refusing to return to campus or the office. While it's unlikely that we can argue that home working is a contractual right if it's just been put in place during the pandemic and they managed to work from the campus previously, we need to try, I think, to avoid simple orders that they simply have to return. It's about communication. It's about understanding their reasons for not wanting to be on campus. It's about trying to put their mind at rest about that and encourage them in the first place. I'll come on to the stick that we can be used with that later. If a reason is health related, you of course need to be mindful of the duty to make reasonable adjustments for disabled employees. So if it is health related, seek medical advice, get an occupational health opinion on it, and please note a later case that Judy is going to update you on concerning associative discrimination in this area. It may not just be the medical needs of the individual employee you have to consider. So take medical advice to help assess if an employee's health condition amounts to disability and whether remote working would be a reasonable adjustment. Also be cautious if it relates to a pregnancy reason for not wanting to return to campus. Check also if they've made a statutory flexible working request. This has a formal process associated with it, and it must be dealt with in accordance with pretty complex legislative requirements, which includes that you must have only one of 8 prescribed reasons for refusing a request, such as a detrimental impact on the quality of the work. But in each case, you need to assess those reasons individually. In all cases, I think you need to seek to allay concerns. Risk assessments are very important in that. I know most institutions have been pretty good at producing return to work risk assessments for staff. You need to ensure that you inform the employee of all the steps that are being taken to ensure that the workplace is as safe as it reasonably can, and you can follow up in writing with details of the measures that have been implemented and the reasons why you're encouraging people back to campus. If someone still refuses to attend, do review the employment contract. Most contracts list place of work as the campus. Assuming that it does, provided you followed government guidance and the campus is as COVID secure as it reasonably can be, you can instruct employees to return to work as a reasonable and lawful management instruction. And if an employee fails to comply, you can take disciplinary action against them, but it needs to be proportionate, taking into account the reasons for their refusal and what other staff are also doing. Ultimately, persistent refusal of a return to work can lead to a final written warning. It can lead to dismissal, which could be fair, subject to you taking those steps, but it does depend on the individual circumstances in each case. Always be cautious, always be sensitive if the reason is related to health and safety. There is legislation that dismissals related to the raising of a health and safety concern can be automatically unfair, not subject to a 2-year qualifying period, and also not subject to a cap on compensation if this dismissal is found to be unfair. So do just be cautious of that. Also, action short of dismissal can amount to a detriment that could also be unlawful, but again, it depends on the measures you put in place to ensure a safe return to work and the concerns, the specific concerns that the employee has. No, working from home guidance is currently revoked. There's none in play. It may come back in. I suspect not. But while there is no external onus on employers to continue home working. The longer that employers allow staff to work from home, the greater the risk that an employee could argue that remote working has become a contractual right via custom and practice. You need to be mindful of this when setting timelines or considering any delays in a return to the campus. I'm now going to pass on to Judy just to give you an update on equality.
Thanks, Patrick. So in this section on equality, diversity and inclusion, I'm going to start by looking at a couple of themes coming out of the pandemic, and then look at some tribunal decisions linked with those issues, and then finish by looking ahead at government proposals. But first of all, another poll for you. So if we could get that up, there we go. So if you could let us know, what are your biggest EDI challenges at the moment? And I think on this one you can choose more than one option. So which of those are the biggest challenges for you at the moment? And if you've got other issues, it'd be really interesting if you could tell us what those are in the Q&A facility. Okay. So that's interesting. Development of junior employees, promotion processes, and equality between those who can work remotely and those who can't. Those are actually all topics I'm going to touch on in a moment, because the sort of research on this area ties in exactly with your feedback in terms of what are significant issues. I think not just in terms of sort of legal equality, but also the senses of fairness in organizations. So that's interesting to see. I'll just have a quick check and see if anybody added any other issues on that. Okay, no, I think that's it. Well, thank you for that. That's interesting. Interesting to see that your feedback sort of ties in, as I say, with the research that is going on in this area. So as I said, I'm going to start with a couple of themes coming out of the COVID pandemic, and I've put a quote there on the slide. And what I would just say here is that in this area, there's a mass of data, a mass of really interesting commentary and research, which quite clearly I'm not going to touch on in any detail at all today. But what I have done is put on later slides, which will be sent to you, links to some really interesting articles and other information that if you want to dig down a bit deeper into it, then you can do. So those will come to you to follow up with. So I said there's a quote on the slide there from the global management consultants McKinsey, who've said that the hybrid models of remote work are likely to persist in the wake of the pandemic, mostly for highly educated, well-paid minority of the workforce. And what that's really highlighting is the risk of a two-tier workforce. And it ties in with the sort of most popular choice in the previous poll, because in reality, the ability to work remotely, including from home, is seen for a lot of people as actually being quite a significant benefit, having that flexibility. But it's not a benefit that is open to everyone. And in particular, it tends to be more available to the highly skilled and senior staff, whereas the lower skilled people in more junior jobs more often tend to have to be in the workplace. And the reason why that's an issue in particular is, well, first of all, there's a sense of, the two-tier. That isn't good for inclusion. It isn't good for, positivity in the workplace. But also, statistically, lower skilled jobs tend to be filled by people with protected characteristics, in particular younger people, females, and people from ethnic minorities. So there is a real equality law potential issue there too. Now, there's no easy answers to this, but I thought I'd just highlight the types of things that employers are looking at around this. There are other types of flexible working, of course, not just around remote working, that have not had quite such a high profile in the context of the pandemic. So, for instance, there's part-time working, staggering start and end times, job shares, those types of things. So, not to forget different types of flexibility that might help people who do have to come into the workplace. There's also an opportunity to look at job design. And the opportunity to consider how all aspects of jobs could be done differently. And then there's also something around practical steps in terms of making those people who have to come into work feel valued and not in some sense like second-class citizens. So, for instance, there's things that some of our clients are looking at in terms of enhancing the workplace environment, refreshing it, adding value into that. And even simple things such as, discounts in staff canteens, etc. So, as I said, no easy answers, but there is a piece of work there, I think, to be done. And again, if you've got any comments or thoughts on that, please do add to the Q&A section. It would be useful to hear. And then just moving on to the disparate impact of the pandemic, and I think, yeah, we're on the right place now. My sort of second theme is that there's a huge mass of data indicating that, unfortunately, people with protected characteristics have tended to suffer more in terms of their work than others. So, for instance, the data shows that people with disabilities have much higher rates of redundancy and reduction in their working hours. And there's quite a lot of work around early career people, for instance, your early career researchers, who, obviously in most cases tend to be younger, who have lost out or feel disadvantaged in their careers because without being in the workplace for a while, they've not had access to working with colleagues and that osmosis where they, learn things and develop by that sort of interaction. And as Patrick outlined, there are also the reluctant returners to the workplace, some of whom may be reluctant to return because of their protected characteristics, in which case special considerations apply. So, in terms of addressing that disparate impact, which is just a few points on the next slide, is, there's no easy way to reduce that disparate negative impact. We might hope that the situation will improve as things get back to normality, but who knows? Your institutions are no doubt looking at ways to address some of this, and I've just sort of picked out a few key things to consider. So, first of all, and I think probably most importantly, is that as workplace plans develop, it's really important to identify the impact and the different impact that those workplace plans can have on different categories of staff. And the best way to do that is by quality impact assessments to identify the disparate impact, particularly where you have negative impacts, and then to implement changes to try to reduce that impact. There are also things around the life cycle of employees. In terms of recruitment, I mean, quite clearly, what we want to do is to broaden, increase the pool for selection to bring the best people into organisations. And I think at the moment it's particularly important to think about what flexibility can be offered at the recruitment stage, and to focus on contribution and outputs rather than on other aspects, for instance, location, etc. And in terms of development and retention, it's really important to consider the individual circumstances of each employee. So, for example, if you're looking at appraisals, do you need to adapt any of the pre-appraisal criteria to take into account, for example, that somebody has been homeschooling for over a year? Again, just some high-level thoughts on that. If you've got any particular thoughts or experiences or questions from your institutions, please do put them into the Q&A section. And then I'm just going to move on to a quick case law update on some recent cases which are tied in with the topics that Patrick and I have been discussing. First of all, I'm going to mention the case of Follows and the Nationwide Building Society. I think this case is interesting for two reasons, primarily. First of all, it highlights the point that Patrick was making earlier, that an employee can have rights under discrimination legislation, in this case, the disability discrimination legislation, because they're a carer for a disabled person, even though they themselves don't have a disability. So it's discrimination by association, as it were. And also, it's a really excellent example of how not to handle a situation where you are wanting somebody to work in the workplace. So I'll just outline the facts briefly. Mrs. Follows was a senior lending manager at the Nationwide Building Society. She had a home worker contract, primarily because, and her employer knew this, she was the primary carer for her disabled mother. And despite having a home working contract, she did, as a matter of practice, come into the office 2 or 3 days a week. She had an excellent performance record, in particular, really good reports on her supervision of more junior staff. So all over, an excellent employee. Nationwide decided to reduce the number of their senior lending managers, and also decided to require those who stayed in the organisation to work full-time from the office. The reasons for that were that, in effect, management thought that it would be better for supervision for these managers to be working in the office. And in the background, there had been some sort of rumblings and slightly negative feedback about some supervision from some of the more junior staff. Mrs. Follows was put at risk. They entered a consultation process. She argued very strongly that she should be able to continue her working practices because they had worked very well for years. She had good feedback on supervision, and also she had the caring responsibilities for her mother. Unfortunately, she was actually made redundant because Nationwide didn't accept that and required her to be in the workplace. The Employment Tribunal upheld a range of claims that she brought, including unfair dismissal and indirect sex discrimination, but in particular, it upheld her claim for indirect disability discrimination by association. In terms of that, the Employment Tribunal accepted as a general proposition that carers of disabled people are less likely to be able to accommodate certain working arrangements than others, and in particular working in the workplace. And as such, Mrs. Follows was at a substantial disadvantage in comparison with others. The tribunal found that the Nationwide had not properly discussed its proposal with her, and in particular alternatives. Nationwide hadn't produced any actual real evidence as to why it was going to be better for her to be working in the office, and they effectively ignored her representations. So, you know, the tribunal held that the Nationwide had taken no reasonable steps to avoid the disadvantage to her. And it said that even if Nationwide had a legitimate aim in requiring her and other managers to work full-time in the office, it wasn't a proportionate means of achieving that legitimate aim. So as I said, what I think this case really highlights is the point around that somebody may have rights under the Equality Act, even though they themselves do not have the specific protected characteristic. I think it also highlights the importance of evidence. If an employer is saying that it is necessary and required for an employee to work in the workplace, you need to be able to go further than sort of asserting that. And then it also, I think, emphasizes the importance of consultation, and real consultation, not just in effect a conversation, but without listening and considering. And then just briefly, another couple of cases on that slide. In the case of Dobson, the Employment Appeal Tribunal formally noted the childcare disparity. And what that means is that the EAT took judicial notice of, is the phrase, without needing any statistical evidence on it, that women are statistically more likely to have childcare responsibilities, and that means that therefore they will have greater difficulty, again, in accommodating certain work patterns. So that leads and confirms the lead into the possibility of indirect sex discrimination claims around requirements in relation to working arrangements. And then just on the final one, Thompson, this is a reminder about potentially high awards of compensation here. Mrs. Thompson was a highly paid lettings agent in a small lettings agency in London. And her flexible working request was turned down after her maternity leave. Now, and it was found to be unreasonable, that refusal by the tribunal. Of course, compensation in relation to a claim in respect of a refusal of flexible working request is pretty limited. It's only up to sort of 8 weeks pay. But of course, she also claimed indirect sex discrimination, tying in with what I was just saying about the childcare disparity. And because she was a highly paid employee, the compensation she was awarded was the best part of £185,000. So just to highlight that in that territory, we're not necessarily limited to the compensation in relation to the actual flexible working request under that bit of the legislation. And then just moving on to looking ahead at what's coming up, just cover this briefly. Staying on the topic of flexible working, the government's consultation on changes to the right to request flexible working ends next month. And that consultation has been around a wide range of things, including whether flexible working, the right to request, should be a day one right with no qualifying period. So I'm sure we will see some significant changes coming out of that. The government has also confirmed its commitment to extend redundancy protection for mothers. And that involves extending it from women effectively on maternity leave to pregnant women as soon as they notify their employers that they're pregnant, and to up to 6 months after they return to work. So the government has said it is going to introduce that, but they haven't given a timetable for it. The government has also responded to its consultation on steps to reduce sexual harassment in the workplace, and has said, amongst other things, that it intends to introduce a legal duty on employers to take all reasonable steps to prevent sexual harassment at work. No specific timetable again, but the government has said that it will be that legislation will be introduced as soon as parliamentary time allows. And then finally, the government has set up an inquiry into the disadvantage to menopausal women that they suffer at work, and what can be done by government policy and also by workplace practices to reduce that impact. And tied in with that, it's notable that the Chancellor announced in the October budget that the cost of prescriptions for hormone replacement therapy for menopausal women will be reduced. So that's a quick sort of scamper through some equality issues and looking ahead. And with that, I'll hand back to Patrick. Oh yes, and sorry, I should just say those are the two slides I mentioned earlier, which was sent to you, which contain a lot more links and interesting material around some of the issues that I was talking about.
Thank you, Judy. So the majority of my work really is acting for universities defending employment tribunal claims by academic and also non-academic members of staff, and I would say roughly 50%, in fact probably more than 50% of those cases tend to have a claim of whistleblowing, detrimental or dismissal. There may be other claims brought, ordinary unfair dismissal, discrimination as well, but often a whistleblowing claim is added to the claims that I'm seeing brought in the sector. Why is this? Well, it's probably because the cap on ordinary unfair dismissal compensation, which is either a year's pay or just above £80,000, is removed in whistleblowing automatic unfair dismissal cases. And also I think employees think that their employers will be embarrassed by matters of alleged public interest being in the Public Employment Tribunal. It's a public forum, so all the dirty linen is aired in that forum. Just a brief summary of the basics of whistleblowing protection. Both employees and statutory workers can bring claims, and they can bring a claim in respect of detriments that happen during employment because they've made a qualifying protected disclosure. They've blown the whistle on some aspect of malpractice they think is happening. They can make a claim in respect of any dismissal, which includes constructive unfair dismissal if they resign because they think that they're being treated badly for blowing the whistle. But they can also bring a claim for detriment after employment has ended, for example, a failure to provide a reference. So it's quite a wide-ranging protection. And as well as employers being potentially liable for any unlawful whistleblowing, dismissal and detriment, individual employees can be personally liable for those acts as well. So it can be quite a significant issue for individual employees, senior managers who've perhaps made decisions. And as well as claiming financial loss suffered as a result of any detriment or dismissal, employees can claim injury to their feelings, but also personal injury in relation to any pre-dismissal detriment. So if they've suffered a detriment for blowing the whistle, which has caused them to go off sick and caused them to have a long-term sickness absence, then you could be looking at significant compensation for personal injury. And that claim can be brought in the employment tribunal as well as the civil courts. It's important to remember the claims about how you treat employees after they blow the whistle, after they've made a disclosure which they say is in the public interest and evidences some kind of malpractice by the institution or an individual employee. It's not actually about how well you deal with the actual whistleblowing complaint. It's not about the process that you follow. It's about how you treat that individual after they've made that complaint. And it's an area that claimants often get wrong and think because their complaint has not been dealt with to their satisfaction that they have been treated detrimentally for blowing the whistle. But one does not follow the other. Claimants also often make the mistake of thinking that blowing the whistle gives them protection against any detrimental action whatsoever. They're immune from disciplinary process. They're immune from dismissal. You quite often see it in redundancy processes where someone's at risk of redundancy will make what they consider to be a qualifying protected disclosure, and then when they're later dismissed for redundancy, they say, aha, you can't do that because I blew the whistle. Again, not the case. It's the motivation of the decision maker that is important. Why is it that they've taken the action that they've taken? Is it because they're looking to punish someone for blowing the whistle, or is it for another reason? And normally it is for another reason, and you can defend the claim. And the couple of cases on the next slide just sort of highlight this area. The first one on slide, Martin versus the London Borough of Southwark. The claimant was a teacher who had expressed concerns that he and other teachers were working excess hours, breaching statutory directed time in that sector. And this looked at what amounts to a qualifying protected disclosure. It's the gateway. You need to have been found to have made a qualifying protected disclosure before you qualify for any protection. And in this case, the tribunal found that none of the 5 qualifying disclosures that had been relied on in the case were actually protected disclosures, and so it dismissed detriment claims. Didn't matter how they've been treated afterwards. They haven't made a qualifying protected disclosure, they're not protected. But the Employment Appeals Tribunal held that actually that was incorrect. The tribunal erred in its approach, and it reminded us and gave a useful reminder of what the test is for what amounts to a qualifying protected disclosure. Firstly, there must be a disclosure of information. You can't make a mere vague allegation. The worker, importantly, must believe the disclosure is made in the public interest. It's not just their own personal interest that they're making the disclosure. It's got a wider public interest aspect to it. Although caution on that, if they're making a disclosure about their contract, it can be quite easily said that applies to others with the same or similar contract, and therefore could be in the wider public interest. The belief must be reasonably held. So the motivation of the person making the protected disclosure is relevant as well. And the worker must believe that disclosure tends to show that one of the issues that have been set out in the legislation as qualifying for protection, for example, that a criminal offence has been committed, has been committed. There has been some kind of procedural or legal obligation that the institution has breached, and that belief must be reasonably held. And the Employment Appeal Tribunal in this case noted that confusion had grown up about the distinction between disclosing information on the one hand and making an allegation on the other, and only disclosure of information which has sufficient factual content behind it being capable of protection. The next case on the slide, Kong versus Gulf International Bank. The claimant here had made a number of protected disclosures, and the tribunal found that the respondents, in this case head of legal, had subjected the claimant to a detriment which had been influenced materially by them blowing the whistle, by them making their qualifying protected disclosure. However, it determined that any motivation on the part of the head of legal could not be attributed to other managers who subsequently took decisions in respect of the claimant in respect of employment, and therefore she lost a whistleblowing dismissal claim. You look at the individual decision maker in this case, were they motivated by the blowing of the whistle in that case now? And then you can attribute the motivation of someone else in the decision making process, but the Employment Appeal Tribunal stressed 3 essential requirements must be met. Firstly, the person whose motivation is attributed to the employer must have tried to procure the employee's dismissal or the detriment because of the protected disclosure. Secondly, the dismissing manager must be influenced by that, must be swayed by that in their decision making. And thirdly, the role or position of the person who did the influenced the dismissal, has to be sufficiently serious so it's capable of influencing the actual decision maker in the case. So quite interesting cases in this complex legal area. And whistleblowing, where next? So it's been subject to consultation in the area of whistleblowing for many years. And back in July 2019, the House of Commons approved a motion calling on the government to carry out a review of whistleblowing regulation to provide proper protection, greater protection for a broader range of people. It's an area they wanted to expand. but actually the government responded to that consultation, believing the law as it stands was actually proportionate, but it did say it would consider improving guidance and working with MPs to address as many of the concerns as possible. The EU whistleblowing directive mentioned on the slide was published in November 2019 and entered into force 20 days later, but member states have until December this year to transpose the directive into national law and to bring into force laws by December 2023. Now, obviously, we're post-Brexit now, and it does seem unlikely that that directive will be implemented into UK law. Indeed, it doesn't need to be, but it is unclear whether domestic legislation will be amended to incorporate these same rights, just to ensure that the UK keeps pace with European worker rights and best practice. So it may be that we see some of what's contained in the whistleblowing directive from the EU brought into UK legislation. Although saying that, UK was one of the EU countries that was deemed to already grant whistleblowers quite good protection compared to other EU countries. But there are some distinctions, some differences between the provisions of the directive and our current domestic legislation. For example, the directive is going to extend protection to facilitators, so not just those who blow the whistle, but anybody who assists the whistleblowers in the reporting process, anybody who gives them information that helps them in their disclosure, third parties connected with the whistleblowers, such as colleagues and family members who might suffer retaliation. And there's also going to be reporting requirements introduced for organisations with 50 or more employees. You'll be required to report within a specific timetable. And the identity of the whistleblower is going to be given more protection. They must not be disclosed without explicit consent to anyone beyond the staff members who receive and follow up on the report. So trying to protect that identity and the confidentiality of the whistleblower more than is currently in play. And finally, member states will be required to ensure that whistleblowers have free access to comprehensive and independent advice on when whistleblowing protection applies and what reporting channels are available and the best routes to take. So watch this space on whether we get an extension of whistleblower protection. Conscious of time and also the number of questions that we've been asked in the Q&A, so I'll just quickly go through industrial relations. Firstly, some proof that employers and unions can work together. I was pleased to see that UCEA and the higher education trade unions work together to provide the sector and its staff and students with a series of joint statements on to return to work, including how to raise concerns, what to do if a health and safety concern is identified, COVID testing for staff, encouraging the uptake of vaccinations across the sector, and the principles for working safely on campus. And again, all these joint statements are available on the UCEA website and well worth a read. Of course, this is how trade union consultation is supposed to work, everybody coming together to further the interests of the university in the spirit of cooperation. But of course, we're often more used to disputes in this area, and we currently have the spectre of possible industrial action on the agenda. UCEA is in the middle of balloting its members for strike action to over 150 universities. I think ballots are due to close tomorrow, looking at the payoff, the national pay offer, cuts to USS, the valuation of USS, and the use of insecure contracts in the sector, looking at hourly paid lecturers, etc. And linked to that, issue of career development opportunities, excessive workloads, and the need to address gender, ethnicity, and disability pay gaps as well. So a whole range of issues that are in dispute at the moment. Some are being balloted on all these issues, some just on the USS. And I know that a lot of institutions are putting a lot of work into many of these areas, for example, the pay gap, casualisation, etc. So it remains to see what appetite there is from staff for strike and how widespread the strike action will be. It's a disaggregated ballot, meaning that we could get strike action at some institutions and not others. So we'll wait to see what the result of the ballot is. Guidance from UCEA on strike action is great, so well worth the read, but we're also helping our clients with ballot and notification queries, issues over how you mitigate the effects of strike. Do you use pre-recorded lectures, for example? And we've also got queries on action short of a strike and whether the institution can withhold pay in those circumstances. always a complex area legally, and also very political, of course, as well. But finally, on this topic, you see, I noticed a started engagement with the HR director community as part of its national conversation on pay bargaining. There's a question over how long the pay bargaining process goes on for. It's always implemented well after the effective date, and there's a question mark over whether the current bargaining structure is fit for purpose and what changes could be made to that process to make it more streamlined going forward. So again, watch this space on that one, and I'll just pass to Judy to quickly finish off on employment tribunals.
Thanks, Patrick. So I'm just going to finish with a short update on what's happening in the employment tribunals. Well, even before the COVID pandemic started, they were struggling with their workload, and clearly it's worse now. So we're seeing long delays in hearings, certainly multi-day hearings, and we've seen hearings listed now for 2023. Or right at the end of 2022. So long delays, and also quite a number of last-minute postponements by the employment tribunal, sometimes literally the afternoon before, because they haven't got an employment judge available because too many cases have actually gone through to the hearing. So it has been difficult and a bit chaotic at times. The tribunals, of course, closed completely right at the start of the pandemic and then opened up to some extent. And for quite a while, what we've had is a mixture of remote and in-person hearings. And actually, I think the general experience of the remote hearings is that they've worked better and been more efficient than a lot of people expected. And also, one interesting thing is that because the tribunal is not taking place in the tribunal building, it means that security doesn't shut everything down at 4:30 or 5 o'clock. So we've seen cases that are done remotely online, running on sometimes till 6:30 in the evening because the judge wants to get through things. So useful for them to have that flexibility, although it can be rather tiring for the participants. So, looking ahead and recognizing that, the big backlog in the tribunals, the Lord Chief Justice has revealed a new platform for remote hearings, which is intended to make the online experience even better. There's been a big judicial recruitment exercise going on, lots more employment judges being recruited. There's about over 100 being appointed recently, many of them part-time. Still a big number to help get through this backlog. And also in the October budget, the Chancellor announced a significant increase for the Ministry of Justice, which includes the employment tribunal system. So and that those increases continue through to 2025. So more coming to the system to try to improve things. But yeah, there's a big backlog, as you would expect, I think. Okay, so just finishing on that, there's quite a few questions in the chat, and we've got just a few minutes, 2 or 3 minutes to look at. Patrick, was there anything that leapt out at you that you saw looking in the questions that you could answer in a couple of minutes?
Yeah, I mean, and they're generally about the return to campus and academics typically refusing to return. I was interested in the question, I think it was from David Smith. We have a number of professors who are refusing to return to campus, stating they've always worked from home or worked a hybrid working model even pre-lockdown, insisting that return to campus is a breach of long-standing custom and practice. You need to explore what the situation was pre-lockdown. Were they indeed working from home pre-lockdown? If so, why? And how was that arrangement arrived at? Was it recorded in writing anywhere that they could do that, and why? It would seem unexpected that they'd have been allowed to do that permanently unless there was a specific reason for it. But if it was expressly agreed with them pre-lockdown that they could, then yes, insisting they return to campus now could be a breach of contract. And if even if there wasn't anything expressly in writing, if this was an expectation based on a long-standing customer practice, that could amount to an implied contractual term. Now, it's hard to imply a contractual term on the basis of customer practice. It has to be reasonable, it has to be notorious. Almost a sense of if an objective person looked at, they would assume they were contractually entitled to work from home. So that's quite a high hurdle to come up to. But you'll need to just explore with them the specific reasons. And it won't necessarily matter just because it's not explicitly referenced in a contract of employment. You need to look around that email conversation or conversations with line managers, etc., to find out. I think, David, you also asked about constructive dismissal. So it's obviously easier to insist someone returns to work if they haven't got any protected characteristics that are preventing their return to work. If they're not clinically vulnerable, if they're not worried about their own health and safety or someone they live with. But you still owe them implied terms of trust and confidence. And so it's about the consultation process in explaining why you're expecting them to come back to campus. And I've seen in another question someone mentioned requiring people back in campus to supervise junior member staff. Absolutely, that's a legitimate reason to be requiring people to come back to work. But it's about a question of reasonableness and proportionality and consultation with staff. If someone feels that they're being treated unreasonably, they can resign and claim constructive unfair dismissal. Now, it's hard to succeed in a constructive unfair dismissal. They have to show there's been a fundamental breach of their contract of employment, and that is hard to do. But if you've taken all the steps to explain all the measures you've put in place to keep campus safe, if you've consulted with them, explain the reasons clearly why you're requiring them to return to work, it's going to be a difficult claim for an individual to succeed in, unless there's a specific reason. So again, it's all about the individual circumstances of each case.
I think I've got one question that I can probably answer in 30 seconds, or give an indication of before we finish, which is there was a question around could long COVID be covered by the Equality Act? Well, the answer is potentially, but not necessarily, depending upon whether the physical impairment that the individual has meets the necessary definition of a disability under the Equality Act. So, quite clearly, it's not one of the sort of defined impairments which is automatically covered. So, and a lot will depend on the likely duration, whether it really is long term, and how long term the substantial effect is on the individual. Okay, so we are at the end of our session. Thank you very much indeed for joining us. Thank you for the interesting comments and questions which we can see, which we will look again at. Please do submit feedback. We're always keen to receive that from you, and in particular, if you would like to suggest topics for future sessions, that would be fantastic. And on that, I think we'll say thank you very much indeed, and goodbye.
Thank you.